We're on.
Okay. Let's go on the record on cause number DC 1810023, Maria Morales versus Burke Grillette and Jenny Watson. Counsel, make your appearance.
Yes, my name is Laura Rivas. I'm attorney for plaintiffs.
Dana Woods, attorney for defendant Burke Grillette.
And Stacy Glenn for defendant Jenny Watson.
All right, I've read the motion. This is an effort to try to get the deposition. I'm not sure if I'm saying like Grillette. Is that how you say the name?
I believe it's Grillette.
Okay. And I haven't heard from the other side, so I've read everything. Why don't you guys want to have her to be deposed?
It's not that we don't want to have her deposed. It's that I gave them a date. They noticed it. And if you don't mind, Your Honor, if I could just give you a very quick timeline.
Sure.
This case has been on file for over 2 years. How it led up to them wanting to depose Mary Grillette, who is not a party to this lawsuit, by the way, is that they had originally sued Alan Grillette, who is the father of Burke Grillette. I know this is going to get confusing, for negligent entrustment. I filed a motion for summary judgment in August. And at that time, they finally decided they needed to depose Alan Grillette to try to prove up their negligent entrustment case. And so they deposed Alan Grillette on September 14th of 2020, 2 years after the case was filed. And at that time, they found out that the records that they had been in possession of since June of 2019, the cell phone records, they had assumed that the phone number belonged to Alan Grillette, and that's why they sued Alan Grillette for negligent entrustment. Well, during Alan's deposition, they discovered that no, that's actually Burke Grillette's mother's phone number. So they then contacted me on, I believe the same day, the 14th, and said we wanted to depose Mary. And so I contacted Mary, even though she's not my client and she is not a party, and I gave them a date of September 21st, 2020. And that is, at this point, 7 days before the agreed upon end of discovery. We had already discussed or extended discovery several months in this matter in order to allow plaintiffs to take several of their doctors' depositions. So I gave them the date of September 21st. And unfortunately, apparently Ms. Glenn in Mr. Renwick's office was not available that day. So Defendant Watson's counsel filed a motion to quash Mary Grillette's deposition for September 21st. I then get an email the afternoon of September 23rd, which is a Wednesday, and our discovery period ends that Monday, telling me that I need to provide new dates, either Thursday or Friday, or once again, extend the discovery period. And I don't have a duty to help them prosecute their case. They have sat on this for over 2 years. They are attempting to get the deposition of the mother who is not a party. And I was leaving for vacation the following Monday. And so I said, I gave you a date, it didn't work. And, they believe that's sanctionable behavior.
Ms. Rivas?
Yes, Your Honor. Dana Woods did have an accurate timeline of the events. We did have, in response to her motion for summary judgment, we did have some documents that had the phone number listed as Alan Grillette's phone number. And that's why we believe that he was on the phone with Burke Grillette at the time of the collision. Come to find out, obviously, it's Mary Grillette's phone number. So we want to take her deposition. We asked for the same day that we found out that it was her phone number. We asked for her deposition dates. Malcolm Renwick or Stacy Glenn, their office has not provided us with any dates that work for them. So given the approaching discovery deadline period coming to an end, we noticed it. In their motion to quash the deposition, they did not provide any alternative dates. They have yet to provide any dates for Mary Grillette's deposition that works for Malcolm Renwick's office. Therefore, plaintiffs did move forward with noticing it just on behalf of the scheduling order and trying to get it done before the discovery period ends. One thing I would add to Ms. Dana Woods' argument is that the agreed scheduling order that we've entered into and signed and filed with the court is actually a Rule 11. It states at the bottom of it that if this case is reset, this should serve as a Rule 11. and the new deadlines will extend from the new trial date, just as they do in the scheduling order. So actually, the discovery deadline is not until January 4th, 2021. Right now, we just don't have any dates from the witness or Ms. Woods other than the September 21st date, and no dates from Malcolm Renwick's office either.
When is this case set for trial?
February 2nd, 2021.
Okay.
Your Honor, if I may, this is the first that, and I agree, I should have read the Rule 11, but this is the first I've heard. Everything with them is you don't agree and we're going to compel and sanction. There's no discussion of, hey, Dana, did you happen to notice that the deadline extends with the Rule 11? Therefore, you know, can we agree to move forward that way? Everything is, I'm going to sanction you if you don't do exactly what I want, when I want. I got a request this past Monday when I returned from vacation asking for my client's verification for his interrogatories that day, or they were going to file a motion to compel and sanction me. And so, you know, I normally work very easily with most plaintiff attorneys that I deal with, but with them, it goes to DEFCON 10 immediately as soon as you don't agree with something. And I'm usually pretty easy to get along with as a defense attorney. So again, I understand they want to take the deposition, but I'm not clear what I've done that is sanctionable at this point.
So why don't we, at this point, I want to get the deposition set. I don't want there to be any delays. So what I want you to do, Ms. Woods, do you have the phone number for Ms. Gillette with you?
I don't have it with me, but I have it, as well as Ms. Rivas has it, and I'm sure I could get it if I need to.
I'm going to put Mr. Tagnon and Ms. Munter into a breakout room with you. I want you, with the three of you, I want you to contact Ms. Gillette. I want you to give Ms. Rivas a couple of dates that that are available for Ms. Gillette and then for you and for Ms. Glenn. And I want you, once you guys have figured out a date that works for you, we'll let you back out of the breakout room into here, and we'll go ahead and memorialize that on the record.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
All right. So, and you guys are all required to come back from the breakout room into this room.
Yes, Your Honor.
Okay.
Yes, sir.
All right. Give me a second. And Ms. Munter, once they do that, go ahead and text me, okay? Did you hear me, Ms. Munter?
Yes, Judge.
Okay. Mr. Tagnon, I want you to play referee here, okay? All right. You can't
Hopefully
make
that won't be necessary.
All right. All right. We're sending you to the room. Okay, while they're doing that, we'll go ahead and take care of this default judgment in cause number DC 202604. Tony, you ready to go on the record? Ms. Woods, you need to go to the other room. I don't know what happened. I hope she's going to go. Let's go on the record again on cause number DC 202604. In re purported lien or claim against. Counsel, make your appearances.
Crystal Gibson on behalf of the petitioner, Nation Star Mortgage LLC DBA, Mr. Cooper.
Okay, let's go ahead and proceed.
Your Honor, I actually filed this application under Chapter 51 of the Texas Government Code. It's simply to have a general warranty deed deemed void and fraudulent. Unfortunately, Mr. and Mrs. Bolton are actually on today. They're the borrowers of a home equity lien that my client has. And in around 2015, they got involved with some shady attorneys and groups, unfortunately, that took advantage of them. One of which was Bormeo Investments. They actually, and the Boltons will corroborate this, they actually forged their name onto a general warranty deed that took title out of them. Just to be clear, we actually do have a federal lawsuit going on with regard to that home equity, but that's separate and apart. But we're not able to mediate or do anything with them because they're out of title. So I volunteered and got the client to get on board with me filing this so that I could have that general warranty deed deemed void based on their representations so that we can go forward and try to work out something with the borrowers. Just so you know, Bormio Investments, their registered agent was Aaron Morales. That's who the Boltons dealt with back then. It was in 2015. Interestingly, the general warranty deed was actually executed on November 10th of 2015. And according to the Secretary of State's office, the charter for Bormio Investments was actually forfeited in February of that same year before the general warranty deed was actually executed. So it was done so fraudulently and then also without authority to do so because their charter had been forfeited. We served Bormio Investments through their registered agent since it was a forfeited company through the Secretary of State. They were served on February 25th of this year, Your Honor. And we got the Whitney certificate back from the Secretary of State, and it's been on file since May 13th. We're just asking the court to go ahead and sign the findings of fact with regard to the application finding that that general warranty deed from the Boltons into Bormio Investments is fraudulent and invalid.
So I'm sharing the default judgment. Let me do this. I need to go. I just printed it out. I'll be right back.
Sure.
Okay. Can you hear me okay?
Yes, Judge.
Okay. So if you look at this, it says on the 12th day of October 2020, and the entitled review the affidavit. And then you have a little checklist here. The documentation or instrument attached as exhibit 4 to the motion hearing is asserted against, and then it says, and I'm not sure why you do it this way. Am I supposed to check this or?
It's the form, oddly, that the government code actually has it listed. I go ahead, what we've done in the past, I've done about 5 of these, and
Okay.
we just check it, Your Honor. Yes, I'm trying to see the second page. Let me just pull mine up.
Okay. I'll go to the second page.
We have our images and our, okay, here we go. So the documentation.
Am I supposed to circle one of these options?
Yes, that it is. Yes, that it is.
So for the first one, what do you want me to create to
The
circle?
court as follows. Only an item checked and initialed as a valid court ruling. Okay, let me look and see which one we want. It's been a while, Judge. I'm sorry.
That's okay. That's kind of why I wanted a hearing.
Yes, I can see why, because it's been about a year since I've done one. Yeah, it's not going to be it's not going to be a lien. So I think it's going to be our second option, because the first one, if you check that, it's going to say that it created an implied or express. So I think it's going to be your second one, Judge. The second blank, the document or instruments attached as exhibit 4 is not provided for by specific state or federal.
No, for the first one, I have to check one of these 3 though, don't I?
Okay, I'm sorry. Motion hearing is asserted against real person. My battery's low. Don't want to see that. Yeah, I thought that we only checked the second box, Your Honor, because it's not. I don't think we have to put a 1, 2, or 3. I think it's the
See,
second.
the first one says is provided for,
Yeah, and
is
it's
created, or is an equitable constructive lien. So it needs, I mean, I think I do need to choose, or do I guess I can,
yeah, I think we marked that out. And it's the second section where it's not provided for and it's not created, it's not equitable, and it's
so do I need to circle any of these or no?
not the first one. I think just the second one, Your Honor. You just check that the blank.
And do I need to circle number 2, or do I,
Right. Number 2.
number 2, okay?
Yes, Judge. Sorry about that. It's very frustrating because that's like what the statute says you have to do, and it doesn't make sense to me, but okay. But yes, the second one and then number 2.
Okay. Let me do this. Okay,
Sorry about that.
that's okay. The court will go ahead and grant the default judgment as requested. I'm going to sign it, and we're going to go ahead and enter it today.
Okay,
So-
thank you so much.
All right, you have a good day. Nice to meet you, Mr. Bolton, Mrs. Bolton.
You too. Bye-bye.
You have a good day. Is everyone back?
Yes, Your Honor.
Ms. Munter, did you lose Julian?
He was in the room with me. I'm not sure why he's not back yet.
Oh, well.
They reached an agreement, so.
All right, what did you guys, Ms. Munter, what did they decide?
We decided on October 29th at 3 p.m.
Okay, well, thank you, Ms. Munder. So let's go on the record just to verify that. Is that correct, Ms. Glenn?
Yes, Your Honor.
Okay, this is the, I don't have this one. Oh, Mr. Bolton, you can head out. Your hearing's over. Okay, let's put this on the record, Tony. Ms. Glenn, if you announce the name and cause number.
I don't have that with me, Your Honor.
Ms. Woods or Mr. Rivas? The name and cause number
Yes,
of the case.
it's DC 1810023. And my name is Laura Rivas, attorney for plaintiffs.
I'm Stacy Glenn for defendant Jenny Watson.
And Ms. Woods?
I got it. Dana Woods for defendant Burke Roulette.
I think there's been agreement reached as setting the deposition of Ms. Gillette. What is the date that the deposition's been set?
October 29th, 2020 at 3 p.m.
Okay. Is that correct?
That
Yes,
is
Your Honor.
correct.
Ms. Glenn?
Yes, Your Honor.
Sorry, they kind of talked over each other. Okay, so what we're going to do, and you can include this in the order, Ms. Rivas, is we're going to order the deposition to take place at that time.
Yes, Your Honor.
If there's any effort by the defendants to stop that deposition from going forward, then I will consider sanctions at that point. But at this point, I'm going to, kind of give Ms. Woods the benefit of the doubt, and hopefully it'll get set and everything will be fine. But if there's a problem, then feel free to bring it back to my attention. So just include that in the order. Anything else, guys?
No, Your Honor. I'll get a new order filed with that date on it.
Ms. Glenn?
Nothing else, Your Honor.
Ms. Woods?
Nothing else.
All right, guys. You guys have a great day. You be safe, okay?
Thank you. You
Thank
too.
you, Judge.
Thank you.